I'm back. Hi. I missed you guys. How has everybody been? I have been terrible. Absolutely terrible. Terrible, 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 terrible. Hey, Judy. Hey, Nancy. Hey, replay crew. Hey, lurkers. I never, ever, 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 ever want that to happen again. I have never been that sick in my life. Well, that's not true because I had cancer twice. Other than cancer, that's the sickest I've ever been in my life. Oh my God. Oh, yes, Judy, it is good to be back. It is very good to be back. Wendy Rittenhouse, Kyle's mother, was rumored to have taken Kyle to Kenosha. She also was said to be fully aware of him having the pew-pew and what his plans were that evening. There is no evidence she knew any of these things and has denied any knowledge until after the fact. I don't think she knew, because if she knew, she wouldn't have allowed it. No mother would allow their 17-year-old kid to go to some place where there were riots with an AK-47. Not a good mom. Hey, Nancy, thank you for supporting the channel. Wow, 2 feet of snow. 11 degrees, 16. Oh my gosh. I'm glad everybody has power. Yes, this is where the cool kids hang out. Just this cool kid has been sick. It's good to be seen. It's very good to be seen. I am okay now. When I was at the vet with Bill, my chest started hurting again, and I was like, no, 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 no. I have, fibromyalgia is just the gift that keeps on giving. Hey, Dave. Hi. I was diagnosed, I think I was 23 or 24, and I just turned 57. And just when you think this is the weirdest disease in the world, and I don't know why people don't believe it, just because you can't see it on the outside. There's plenty of diseases you can't see on the outside. You can't look at someone and tell they're diabetic. I mean, I don't get it. Why do people not believe it? But just when you think you're on all the right medications and stuff and you've got it under control, it's like then you get some new symptom. So anyway, I'm on this cocktail of medications that has got me pretty much under control. Now, I still have the arthritis, so I still have a lot of pain in my joints, and that's going to have to be taken care of with surgery and shots and whatever else. But about 5 years ago, I started having this chest pain, and it's called costochondritis, and it's where your ribs attach to your sternum, there's cartilage, and that cartilage gets inflammation and it causes pain. Hey, Teresia. And usually it's pretty much localized right in here. And I can take some Tylenol, put a heating pad on it, and I think maybe a couple hours is as long as it's lasted in the past. This time, on day 5, I was like, I'm done. I'm going to the doctor. But if it lasts that long, you know it's not your heart, because I would have been dead. Because if your heart hurts for 5 days, that's not possible. So I knew it wasn't my heart, but it was just my whole entire torso, just about, and my shoulders and the top part of my back. And I was miserable. Like, I was ready to go to the emergency room. I was so bad. And I was like, no, because if you have fibromyalgia and you go to the emergency room, they think you just want pain medicine. They think you're just a junkie, because they don't believe you. And so when I went to the doctor, she knew exactly what to do, and she did it, and it worked. But she said, if it doesn't get better, go to the emergency room. I said, well, I was going to go to the emergency room, but if you go to the emergency room and tell them you have fibromyalgia, they think you're just drug seeking. And she goes, don't tell them you have fibromyalgia. Tell them you're having chest pain. Hey, Deb. This is my friend, Debbie. She is so sweet. So what she did, they gave me a shot of an anti-inflammatory medication. And then they put me on, it's called a Medrol dose pack. Basically, it's steroids, and you take like this big dose on the first day. So you get like a jolt, and then you wean off. Then the next day's dose is smaller and smaller and smaller. Well, I took that big dose the first day, and then the next day I couldn't stop throwing up. So I had to quit taking that. And I was like, great. Now I am going to have to go to the ER because I can't keep anything down, and I can't take the steroids. But I had Travis go to the store and get me, it's called Imitrol. It's like this super, super sweet cherry syrup. It's really good if you like sweet stuff. A lot of people don't like it because they don't like sweets. I love it. And it immediately stopped the vomiting, because if it had not, I would have had to go to the ER. I'm like, great. Now I'm going to have to go to the ER anyway. But no, I didn't. So, and then the pain finally went away. So, for some reason, the doctor sent the prescription to 2 different pharmacies. So now I have the box that I took the 1-day dose out of. I have all the doses left for the rest of the days in that one. And I have a full box of the other one. So I have backup steroids now. So if it happens again, I don't want it to happen again. But if it does happen again, I have steroids, and I will take them. Even if it makes me throw up, I will take them, because I don't want that to ever, 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 ever happen again. And the thing with it, which is different from heart pain, is that if it's your heart, it doesn't matter how you move. The pain doesn't change. But with this, position makes it worsen. So I would be comfortable in the bed, not pain-free, but comfortable in the bed. And then I would get up to go do something, and it would start to hurt worse. So a couple times I would get up, and by the time I got to the door of the bedroom, I would be in so much pain, I would just stop and look at Travis, and he'd go, what? Well, I was going to go to the kitchen to get such and such, but I can't walk any farther. And he'd go, okay, I'll get it. And then I go back to, he's so good to me. But so that is where I've been. I think I flared up because, remember, I had that flu that everybody got. And I think all the coughing and everything, just like flared up all the, muscles and cartilage and everything in my chest. Why it waited like a week in between, I don't know, but I think that's what I did. And then, like I said, I had a little bit today when we were at the vet, but it went right away. And that's normal. It'll flare up for like 15, 20 minutes sometimes. And then, but so yeah, I am back to normal now. Thank God. Because that was a lot. And then, hey, John, because I kept thinking, that's why I kept making so many posts, because I was like, they're going to think I abandoned them. I'm going to lose my channel because everybody's going to have other things. They're going to start doing other things and going to other channels and watching other people. And I'm going to come back and no one's going to be there. But look, 7 of you guys are here. Even we started late because I had to take Belle to the vet. That's why I didn't stream on Friday, because I thought I was going to be able to take her to the vet on Friday. And then they were like, no, we can't fit her in. We can't even work her in today. So, and she has a urinary tract infection again. I think she keeps one. Like the antibiotics will clear it up and then it comes right back. And ear infections, which I didn't know she had, but it makes sense. Because you know how like you'll take your dog's head in your hands and just like, like play? She will like jerk her head back when I go to do that. So that makes sense. I thought it was her teeth. I thought maybe her teeth were hurting. But I guess it was her ears. So I am broke now. $200 vet bill. And we went to Epcot yesterday. And my husband does not have an annual pass, so I had to buy him a ticket. And then I said, I want to go to Animal Kingdom next weekend because the dinosaur ride is closing and I might do a live stream. And he goes, oh, dinosaurs closing? I want to go. I was like, this is why I told you to get an annual pass. We don't have money for another $200 ticket. True. Okay. So we are on Kyle's cross-examination, and this is the best part of the trial because Judge Schroeder goes off on the prosecutor.
Good morning, Mr. Rittenhouse.
Good morning.
Everybody that you shot at that night, you intended to kill, correct?
I didn't intend to kill them. I intended to stop the people who were attacking me.
By killing them.
I did what I had to do to stop the person who was attacking me.
By killing them.
2 of them passed away, but I stopped the threat from attacking me.
By using deadly force.
I used deadly force.
That you knew was going to kill them.
I didn't know if it was going to kill them, but I used deadly force to stop the threat that was attacking me.
You intentionally used deadly force against Joseph Rosenbaum, correct?
Yes.
You intentionally used deadly force against the man who came and tried to kick you in the face,
yes.
Correct? You intentionally used deadly force against Anthony Huber, correct?
Yes.
You intentionally used deadly force against Gage Grosskreutz, correct?
Yes.
With regard to Joseph Rosenbaum, you fired 4 shots at him, correct?
Yes.
You intended to kill him, correct?
I didn't intend to kill him. I intended to stop the person who was attacking me and trying to steal my gun.
Since August 25th, 2020, this is the first time that you have told your story.
Sustained.
Since August 25th, 2020, you've had the benefit of watching countless videos of your actions that night, correct?
I've seen certain videos, not all of them. I've seen the majority of them actually here during the trial.
You've also had the opportunity to read articles. People have written interviews, things like that, about what happened that night, correct?
I do my best to avoid what people write on the internet. A majority of it's not true.
You have also sat here through 8 days of trial, correct?
Yes.
And you've had the opportunity to watch all of the videos that have been played in this trial?
Yes.
Sir, if you could please let me finish my question before answering. And I will do my best to let you finish your answer before I go on to the next question. Fair?
Yes.
You've also had the opportunity to listen to the testimony of all 30-some witnesses that have testified in this trial so far, correct?
Yes.
And after all of that, now you are telling us your side of the story, correct?
Correct.
I'm going to ask you folks to go in the library for just a second. Please don't talk about the case.
Here we go. Oh, yes, he is, Nancy. Yes, he is. Oh, I'm talking about the prosecutor.
Commenting on my client's way through being signed.
You need to account for this.
Your Honor, I don't want to jury here. He's commenting on my client's right to remain silent.
No, Your Honor. I am making the point that after hearing everything in the case, now he's tailoring his story to what has already been introduced.
The problem is, this is a grave constitutional violation for you to talk about the defendant's silence. And that is,
Oh, I know.
and you're right. You're right on the borderline, and you may be over, but it better stop.
Understood.
This is, I can't think of the case, the initial case on it, but this is not permitted. All right. Ask the jury to come in, please.
Oh, wait, this isn't that's not the part where he goes off on him. But he does. I thought that was the part. I thought it was when Kyle was on the stand. Oh man, I hope I'm not wrong.
I've sustained the objection.
You were armed with an AR-15 semi-automatic rifle that evening, correct?
Yes.
You had it loaded with 30 rounds of full metal jacket ammunition, correct?
Yes.
That weapon with 30 rounds is capable of killing at least 30 people, correct?
Yes.
You had arranged to have Dominic Black purchase that weapon for you in Ladysmith, Wisconsin in early May of 2020. Is that correct?
We were up north shooting, and not shooting. We were up north going camping, and Dominic Black brought his rifle, and we were talking. I was like, "Hey, what if we get a rifle for me? I'll give you the money. You can purchase it. It's yours until I'm 18." So I bought the rifle for Dominic, and I can use it. But once I'm 18, we can do a private sale, and we can have it turned over to my name once I turned 18.
Because you knew as a 17-year-old, you could not have that gun, correct?
I knew I could not buy that gun.
You knew you could not possess that gun also, correct?
No.
You weren't aware that under Wisconsin law,
I'm going to instruct the jury later about the law. So, and that he wouldn't, what he thinks on the subject is not dispositive anyway. So, it was unlawful for him to purchase the gun.
it wasn't just unlawful for you to purchase it, it was unlawful for you to bring it home, correct?
In Illinois, I wasn't able to bring it home because I didn't have a FOID card, a firearm owner identification card.
You
in
knew
Illinois.
You knew in Illinois that you couldn't get that until you turned 18, correct?
No, you can get a FOID card at 16 in Illinois.
But you didn't have one.
I did not.
And even after this gun was purchased for you in May, you never got one after that either, did you?
Actually, I applied for a FOID card in May of 2020, but due to the charges, and there was a backlog in Illinois for the FOID card, but after you filed the charges against me, it was denied because of the charges here in this state.
You found out about that after you were criminally charged in this case?
I found out about this in November of 2020. A letter was sent to my old residence.
So you knew that without that FOID card, the gun could not go back to your residence in Illinois, correct?
Correct.
And you agreed that the gun would be kept at Dominic Black's stepfather's house here in Kenosha, correct?
Because he had a safe, yes.
And you agreed that you wouldn't have access to that gun, correct?
We agreed that the only time I would use the gun is when I was with him and we would go to like the Bristol shooting range or up north to his land.
But the only time prior to the night of August 25th, 2020, that you ever used that gun was up in Ladysmith, correct?
Correct.
So you didn't go to the Bristol shooting range ever.
I
with that
did.
gun.
Not with that rifle, but I did.
Pay attention to my question, please. You didn't ever go to the Bristol shooting range with that gun, correct?
Correct.
And you picked out that gun because Dominic had it, correct?
Yeah.
You could have, if you wanted to, chosen from any number of guns that were for sale. Fair enough?
That were at that store. There weren't many, but yes.
I'm sure the store in Ladysmith isn't the only store that sells guns, correct?
You can ask questions.
That was a question.
No, it was a statement.
Isn't it correct, Mr. Rittenhouse, that there are other places to purchase guns besides that one store in Ladysmith, Wisconsin?
I believe so, but that's where we're at, so that's where we got the gun.
And you, if you wanted to, could have given Dominic Black money to purchase a gun at other locations. Fair?
Didn't cross my mind, but now that you say it, yeah.
Why did you pick
What do you think about this
or
trial?
want Dominic Black to buy for you an AR-15 as opposed to a pistol or a shotgun or some other type of rifle?
I cannot legally possess or carry a pistol because I'm not 18 in Wisconsin. I believe it's 18 in Wisconsin for a pistol. But with the rifle, I knew I could possess that rifle. I knew I couldn't buy it, but I knew I could like take it to like the shooting range or possess it. And with shotguns, they didn't have any shotguns in stock. That was my original plan, to get a shotgun for trap shooting. But there weren't any at that Ladysmith store, and I didn't want to go to Walmart and buy one.
So your understanding at that time was that Wisconsin law prohibited you as a 17-year-old from possessing a pistol, but you could have an AR-15?
Yes.
What was that understanding based on?
The understanding was based on when we would go up north. We were it was me, Dominic, and my sister, and we were allowed to carry the rifles around. And the officers over there said it was fine.
I'm going to move to strike this hearsay. What officers would have told
You
them.
asked the question on what the source of his knowledge was. It's not admissible, and none of this is, frankly, and that's why I interrupted before. What the defendant believes the law to be, what the district attorney believes the law to be, what the defense believes the law to be, are irrelevant. I will tell you when I instruct you what the law of Wisconsin is pertaining to the possession of a firearm by a person under 18, and that'll be the source of your knowledge. I'm allowing the testimony right now because it bears on. There's an old maxim under the law: ignorantia juris non excusat. Ignorance of the law is not an excuse.
Okay, everybody say hi now.
Ignorance of the criminal law is not an excuse. If you commit a criminal act, whether you knew it was criminal or not, you're responsible for your conduct, and because you're responsible to know the law. It's not relevant, except in this case, there are specific issues about his awareness and knowledge about certain conduct that is relevant on some issues. So it's quite complicated. Hopefully it'll sort out when I instruct you at the end. But that's why I'm allowing the questions and the answers. But do not be confused about anything that these people say is not necessarily accurate as to the state of Wisconsin law. Any question about that? Okay, thanks. Go ahead.
So you're telling us that the reason that you wanted Dominic to buy you an AR-15 as opposed to a pistol is the only reason was because you felt you couldn't lawfully possess a pistol?
Correct.
You didn't pick out the AR-15 for any other reason?
I thought it looked cool, but no.
You didn't pick it out because you wanted to go hunting with it, did you?
No.
You didn't pick it out because you were going to use it to protect your house, correct?
Correct.
You picked it out because it looked cool.
I thought it looked cool. Guess that's the reason, yes.
It resembled the types of weapons that are used in first-person shooter video games, correct?
I don't really play first-person shooter video games. I have, but I believe there's a variety of guns, including shotguns, pistols. There's guns in video games that resemble all guns.
Isn't it true when you would hang out with Dominic Black, you'd play Call of Duty and other first-person shooter video games?
Sometimes.
And those are games in which you use weapons like AR-15s to pretty much shoot anybody who comes at you, correct?
It's a video game where two players are playing together. I don't really understand the meaning of your question, to be honest.
Isn't one of the things people do in these video games try and kill everyone else with your guns?
It's a video game, dude.
Yeah, the video game, it's just a video game. It's not real life.
Now, you introduced yourself as living in Walworth County right now. Is that right? On the date that this all happened, you were an Illinois resident?
Correct.
You had grown up in Illinois?
Correct.
You had not spent any significant time living here in Wisconsin, correct?
No.
You'd agree with me that's correct?
No, I've spent time at my father's house and partially live here also, so no, that's not correct.
You indicated you had attended, was it Penn Foster High School?
Yes.
That's an online high school?
Correct.
So you were not attending high school in person?
No.
And at the time that all of the things in this case were happening, from the time the AR-15 was purchased to the night of August 25th, you were 17 years old that entire time, correct?
Correct.
Could we have exhibit number 7 up, please? I have put exhibit number 7 up on the screen. Do you recognize that?
Yes, that's my old TikTok account.
That was a TikTok account that you had during the summer of 2020, correct?
Yes.
And it says your name on there, Kyle?
Yes.
Your username on TikTok was 4 Doors More Whores?
Yes.
And that's a picture of you there with your AR-15, correct?
Yes.
And underneath that, you have put on your profile the phrase, bruh, B-R-U-H, I'm just trying, T-R-Y-N-A, be famous. Is that correct?
Yes.
You're the one who wrote that.
Yes.
You testified that at some point you were involved in some sort of EMT cadet program.
I was a firefighter EMT cadet at Antioch Fire Department.
When was that?
I was a cadet at the Antioch Fire Department. I believe from 2018 or 2019 up until the incident of August 25th.
An EMT cadet is someone who's just beginning the process of eventually achieving full EMT certification. Is that correct?
No.
Were you studying to be an EMT before August 25th, 2020?
I was learning about certain things in the field of firefighting and EMS.
But that's not actually formal classes, is it?
No, we met once a week, and we would either, depending on the day, we would either do EMT stuff like learning how to do airways, or we do firefighter stuff like doing hose drags and learning how to crawl through buildings.
And these are things that you did with the, which firefighter? Antioch Fire?
Antioch Fire Department.
You weren't a member of the fire department, were you?
I was.
You were a actual on-duty member on the roster of the Antioch Fire Department?
No.
So when you say you're a member, what do you mean?
I was a member of the Antioch Fire Cadet program. We were issued shirts, Antioch Fire Cadet member. We would help with the pancake breakfast at the VFWs, and we would wear Antioch Fire Department staff shirts. I still have one in my closet.
Maybe I didn't express myself clearly. You were not a member of the Antioch Fire Department, correct?
I was a member of the cadet program, which was through the fire department.
So you'd go out and fight fires?
We can go on ride-alongs, but we can't go into burning buildings for liability reasons.
You'd go out there and you'd save people from burning buildings?
Not me personally.
Because as a cadet, they would never let you anywhere near that, right?
They wouldn't let any of the cadets go into an actual live fire.
At the end of whatever this program is, you weren't actually going to be an official firefighter, were you?
No, it's to help prepare you for.
Good Lord, this boy is scary. He is scary because you give him an inch, he takes a yard. Like, he thinks because he's a fire cadet that he's part of the fire department. That when I was a nurse, and I wasn't a teacher, but when I worked at the hospital and nursing schools in the area did clinicals, they would come and a student would be assigned to me. Some nurses loved it. I didn't mind it. In fact, I did at times say that I loved it because I did like to teach. But at the same time, it's scary because you're still responsible for your patient. Hey, Warrior Sentry. So I didn't mind it. There were some nurses who was like, oh, cool, I have a student today, so I don't have to do anything. No, you're still responsible for your patient. So you have to go behind your student and make sure what needed to be done got done and was done correctly. But I hated it when I had students that thought they knew what they were supposed to do and didn't ask questions, or didn't know how to, worse was didn't know how to do it and didn't ask questions. They just decided that they were going to try to do it not knowing how to do it. And that's the way he thinks, that, you know, oh, I'm a nursing student, but I'm in the hospital taking care of a patient, so, you know, I'm just going to do it. No, you ask questions. You're not the real thing yet. You don't claim to be the real thing yet. You're still learning. If you think just because you're in the actual situation with something on your shirt that says you are, no, absolutely not. And what, Nancy, what is he doing now? Is he a nurse? Isn't he something in the medical field? He's scary. Absolutely scary.
The firefighter EMT academy.
And you weren't going to be an EMT at the end of this program either, were you?
No.
You know that to be an EMT, you have to be 18 and a high school graduate, correct?
Depending on the state, in Illinois, you can take a class at the college at 16 and you can have your EMT license by the age of 17. I wasn't in that class, but in Illinois you can.
You never did any of that?
No, I was online school.
The night of August 25th, you're here in Kenosha, Wisconsin, saying you're an EMT, correct?
Yes.
That was a lie.
Yes.
You were also telling people you were 18 or 19 years old. That was a lie too, right?
No, I didn't tell anybody my age that night.
You never volunteered it at all, did you?
I didn't.
Because you knew as a 17-year-old you shouldn't have been there, right?
No, I just didn't find it relevant to give my name. Well, I gave my name, but my age to anybody. It wasn't something that came up in conversation.
It's because you felt if people found out how old you were, they'd realize you shouldn't have been there, right?
No, it just because it didn't come up in conversation. If somebody would have asked, I would have been like, yeah, I'm 17.
So you felt that as a 17-year-old, it was appropriate for you to be out on the streets of Kenosha with an AR-15 that night.
I thought he told people he was 19.
Fair?
I believe I had any other right to be there as anybody else.
As any other adult.
As anybody.
But you weren't an adult.
No.
You indicated that you were working at the Recplex and had been working at the Y before that. Is that right?
Yes.
That was a YMCA down in Illinois, correct?
Correct.
And you had gotten furloughed there when COVID hit in March?
Yes.
And you had only started working at the Recplex on August 14th, correct?
I believe I got hired before that, but I was on vacation on August 14th, so I was on vacation, so I couldn't start until August 14th.
Your first time working at the Recplex was on August 14th, correct?
I believe that was my first day.
And then you worked the week after that from August.
What is it that Judge Judy says? If you tell the truth, you don't have to keep track of your lies.
August 17th to August 23rd, correct?
I believe so. Till August 24th, I worked.
And then your final shift was on August 24th, correct?
Yes.
You worked a total of 41 and a half hours at the Recplex, correct?
That's the number you got?
And you were a lifeguard.
Yes.
You were walking around their swim area with one of those red, long, life-saving things, monitoring the pool,
A
correct?
rescue tube, yes.
Okay. So, but that was at the indoor pool at the Recplex?
It was at the indoor. It was at the. I don't know if you're familiar with the Recplex.
I am.
I guarded the water park area and the competition pool.
Okay. So they've got a water park area with a slide and a zero entry pool. Is that right?
Yes.
And then next to that, they've got a larger, almost Olympic-sized pool where swim meets happen.
50-meter competition pool divided in half to make it a 25.
Okay, and you were lifeguarding at both of those.
I would rotate. We had rotations, and me and other guards, we would do three. We had 3-person shifts. We would rotate out, watching the different areas of our zones.
You indicated that at no time did this gun, this AR-15, ever leave the state of Wisconsin. Is that right?
Other than the night after, other than that,
Before the shootings.
correct.
There was a time, though, where you wanted to have it with you down in Illinois, isn't it? It wasn't there?
I believe there was a time when me and Dominic were mad at each other. Yeah,
You were mad at Dominic,
me and Dominic were mad over something.
and you wanted to have the gun with you down there?
I think I said something along those lines.
You'd agree with me that let me back up for a second here. You have testified to this jury that you used deadly force against Joseph Rosenbaum, Anthony Huber, the man who attempted to kick you in the face, and Gage Grosskreutz on the night of August 25th, correct?
Yes,
And you did that because you felt that your life was in danger from those 4 people, correct?
yes,
And you are telling this jury that it was, in your mind, justified to use deadly force to protect your own life, correct?
yes,
You'd agree with me that you were not allowed to use deadly force to protect that CarSource building, correct?
Well, I wasn't using deadly force to protect the property. I used deadly force to protect myself. So,
Please listen to my question and answer my question if you can. You'd agree with me that you were not allowed to use deadly force to protect that CarSource building, correct?
yes,
You'd agree with me that you were not allowed to use deadly force to stop someone from smashing the windows of an unoccupied parked car, correct?
I don't think you could use deadly force for that.
You'd agree with me that you can't use deadly force to stop someone from lighting a metal dumpster on fire, correct?
Correct,
You'd agree with me that you can't use deadly force to stop someone from tipping over a porta potty, correct?
correct,
You'd agree with me that you can't use deadly force to stop someone from lighting a flatbed trailer on fire, correct?
correct,
You'd agree with me that you can't use deadly force to stop someone who is about to start an unoccupied car on fire, correct?
correct,
You'd agree with me that you can't use deadly force to stop someone from lighting some traffic cones in the middle of the street on fire, correct?
correct,
So you understand that there's a difference between using deadly force to protect yourself and using it to protect property, correct?
yes,
And you'd agree with me that you're not allowed to use deadly force to protect property, correct?
yes,
But yet you have previously indicated that you wished you had your AR-15 to protect someone's property, correct?
I'm going to ask you to go into the library again for a moment, please. Please don't talk about the
He
case.
forgot to defend property. He brought it with him so people could see it as a deterrent. Somebody sees a gun, they're not going to misbehave because they're going to be afraid they're going to get shot. It was for looks. I'm not saying it's right that he had it because he shouldn't have had it, but I'm just saying that's why he had the guns. For personal protection and for deterrence. Yeah, I agree. Because I think he, not stupid, but a stupid kid.
Your Honor,
I'm not talking about his intelligence.
he's either
Right.
forgetting the court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's
Okay,
asking the questions.
This might be
I
it.
asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an experienced attorney, and he knows better.
Mr. Finger?
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you.
There we go.
My understanding of
You should have come and asked. for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. I did. I granted.
We did not move
That
to
was
reconsider.
their motion.
We have not filed any
Forgive me.
motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed another acts motion on this exact issue because, in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect,
I'm not going to rehash the motion. That's absolutely untrue. No. Your arguments of record, my comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed. Even if you're correct in your assumption that you know more than I did at the time, you should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
Your Honor, there have been things in this case, testimony in this case, that I believe opens the door to this. For example, the defense has introduced evidence that the defendant pointed a gun at a man wearing yellow pants because that person was on a car on the car source lot. Now, there's no justification that I can think of why the defendant would point that gun at someone. The defendant has just testified this morning that he agreed with that person in the yellow pants, that he pointed the gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he's acknowledged that he told the person in the yellow pants, yeah, you're right. I did point a gun at you when you were sitting on a car.
He said, I did. That's what he
Exactly.
meant.
So he's agreeing. May I finish, please? I'd like to have a chance to make a record if I could, without being interrupted, if that's okay. He has mentioned that he's acknowledged that he's used this gun to protect property. He's also just acknowledged that he knows he can't do that. I am attempting to impeach him now with the prior August 10th incident, 15 days prior, involving the same gun, where he is threatening to use that gun to protect property.
He didn't have the gun with him.
Your Honor, he is saying he wished he did so he could shoot people.
You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was unarmed.
I want you to tell me what the defense theory of the case is. May I
respond to what you just said, Your Honor? I'd like to respond to what you just said.
Slow down, please?
I apologize, Madam Court Reporter, but I'd like to try and make a record without anyone interrupting me, if that's okay. I believe that there is a central part of this case that Mr. Rosenbaum is making threats that he has no ability to carry out. So, to your point, Your Honor, you're arguing that this August 10th incident, one aspect of why you don't believe it's relevant is the defendant didn't have the gun with him. This case is about someone who didn't have a weapon, and yet the jury is being told because of those threats, that means the defendant has to defend himself. So, with all due respect, Your Honor, mere verbal threats have already been shown to this jury and used as a basis for someone's subsequent actions. I am attempting with the defendant to use his mere verbal threat on August 10th, 15 days prior, that he's going to shoot shoplifters with his AR-15 to impeach the defendant in a murder trial. I would ask the court's forbearance to do that. I apologize, Your Honor. You're right. I probably should have brought this to your attention earlier. I may have misunderstood your ruling because I thought your ruling was if the evidence in this case made that more relevant, you would admit it or at least consider it it's an admittance. I believe, based on the evidence that we've heard, and more specifically, exactly what the defendant said earlier about admitting pointing a gun at someone who was merely jumping or sitting on a car, that the door is open now to this testimony. And I continue to believe that his state of mind, his intent, his belief as to self-defense is the core of this case. That was the basis for my motion. You were strongly inclined against it. I understand that. But now we're in the middle of trial, and there's been a lot of evidence that's come in that I think makes this relevant. So I'm attempting to impeach the defendant on his beliefs. I believe I'm entitled to impeach the defendant on his beliefs and on his statements.
I'm going to interrupt you now because you're talking about his beliefs. I think that's what they call
his statements to, Your Honor, because he just said, can't use deadly force, can't threaten to use deadly force to protect property. So now I'm impeaching him on that.
Your Honor, the court has seen no reason to change its ruling. And just so this record is clear, in spite of the lengthy statement by Mr. Binger, before we started today, the court specifically stated in Mr. Binger's presence, there's been nothing to have me change any of my rulings. There have been numerous occasions during this trial where they've opened the door. The one time when they're going into Mr. Rosenbaum's prior, the reason he doesn't like guns, and I said something, I whispered in Mr. Krause's ear, it's because of the prior convictions. Please stop. And he did. He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense
Don't
testimony.
get brazen with me.
There it is.
You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now. If it's not similar, that's the whole rule. Those are all the exceptions to 90404. Check the authorities, Wigmore and evidence, Judge Weinstein, Colonel McCormick. It's the prior act has to bear the signature of the accused, or it has to be so similar as to suggest it's a common plan or something like that. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions, whether premeditated murder or whether self-defense. That's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in, no matter what you think. Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule.
4 months. Yay.
I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.
That prosecutor is just gonna do. Okay, Dev, no worries. That prosecutor is just gonna do what he wants to do, no matter what. I think he should have been charged with something. I don't think he should have got off scot-free. I don't think.
Folks, the objection has been sustained. Go ahead, Mr.
I don't.
Thank you, Judge. So I want to turn your attention.
Just to be clear, because I don't want to anybody, especially with my new people here, Debbie and Warrior. I don't want anyone to think that, because I am on Kyle's side in a way, but yes, it was stupid for him to be there. It was stupid for him to have the gun. None of this would have happened if he hadn't been there and if he didn't have the gun. And even if he'd been there without the gun, it might not have happened. But I don't think that he committed first-degree intentional murder. So I don't think he should have gone to prison for the rest of his life. I mean, for crying out loud, he's 18 years old. Judy! Thank you. Thank you. So if I sound like I'm on the defense side, I kind of am, but it's the age and the stupidity. I shouldn't say stupidity. I should say unexperienced. I don't know. You guys know what I mean.
Attention to the day of August 25th, 2020.
Okay.
You had spent the night at Dominic Black's house, is that right?
Yes.
And you indicated that you had worked at the Recplex the night before, is that right?
The 24th, correct.
Okay. And you worked until about 7 p.m.?
I couldn't give you an exact time, but I'd say I got off around.
Okay, so we got. Let me see. If I can get it to scroll back down. We got Debbie Bernfeld, Jill. We got Ken, who I haven't seen in a while. Well, I've been gone for a while, so we got just Stephanie, Britt Ketchel. I haven't seen Britt in a while either. Magic Adventure, such Jen, Ian Barlow, Haley Mouse, Recovery Addict, Vicky LP. Congratulations to the new members. Yay.
Between 6 and 7. I don't recall. It's been a while.
And then you drove your car over to Dominic's house?
Yes.
Okay, so the rest of the time, it seems like you're being driven around in Mr. Black's car. Is that fair to say?
Yeah.
Why did you guys use his instead of yours, if you know?
At the time, I didn't have a driver's license, and I would drive just to get to work and sometimes go to Dominic's dad's house.
So even though you didn't have a driver's license, you drove from your home in Antioch to the Recplex to work that day?
Yes, to be able to get to work.
And then after work, you drove without a driver's license to Dominic Black's house.
Yes.
So I assume then on the week prior to that, when you drive yourself to work, that was also without a driver's license?
Objection to this.
What's going on?
I'll move on. So you drove to Mr. Black's house, you left your car there,
Yes.
and you spent the night at his house.
Yes.
And then the next day, you guys woke up at some point and came down to Ruther. Is that right?
We spent the night at his house and had dinner, woke up in the morning, had breakfast. We were going through I was on social media and we saw the damage and we saw the car store. So we decided to go downtown.
And you came down in Dominic's car.
Correct.
And you said that there was a time in which you were cleaning graffiti at Ruther.
Yes.
And then at some point, I believe you said, and I want to make sure I'm understanding the timeline here, that you went to one of the car sources and encountered the owners, Sam or Sal or whoever they are, correct?
Yes.
Which of the car source locations was that?
It was the car source right here.
And that's the one at the northeast corner of 59th and Sheridan?
Correct.
And that's the one that had gotten totally burned out on one of the previous nights?
Yes, that was the one where everything was destroyed. The other car sources still had cars there. So
Now, before that, had you ever worked at Car Source before?
I have not.
Had you ever bought a car there before?
I have not.
Had you ever even heard of Car Source before all that?
Yes.
Through Dominic?
Well, no. I would drive past it on a daily basis. I was in Kenosha almost every day, and I drive down Sheridan Road almost every day.
Okay. So you saw the business along with the churches and the ultimate gas station and the courthouse and everything else in that area?
Yes.
And you talked to these owners yourself?
Me and Dominic did.
And did they ask you to come protect the property?
They didn't ask me
Directly?
They didn't ask me directly. They asked Nick Smith.
Okay. And was Nick Smith around for that at that moment?
He wasn't there when me and Dominic were talking to them.
Did you ever personally witness any of these Car Source folks, Sal or Sam or any of the folks that were running that business? Did you ever personally witness them ask Nick Smith to guard any of their properties?
No.
Did you ever witness any of them ask anyone to guard any of their properties?
Not that I can recall.
What time, if you recall, did you find out that they'd asked Nick Smith?
I believe I said
Oh my
in
God.
my direct examination between 3:15 and 3:30.
And that was shortly after you had sent a text to Sam, right?
Correct.
And you texted him and asked him
No.
if you could protect his business that night, correct?
I did.
And in that text, you said, "I'm more than willing and will be armed," correct?
Yes.
You meant you'd be armed with your AR-15?
Yes.
And you said that me and my brother would both be there armed, correct?
Yes.
By your brother, you meant Dominic?
Yes.
He's obviously not legally your brother.
No.
And you said in the text, "I just need address." Do you recall that?
Yes.
Why did you need the address of a location you'd already been to?
I just wanted to pinpoint it and on the Google Maps because GPS, because with all the roads were closed down in Kenosha. I just wanted to know the best route to drive there with Dominic.
But you just told us that you drove past here every day up and down Sheridan. Why did you need GPS to help you find a place that you drive past every day?
The roads weren't closed when I drove past them every day.
But you still knew where you were going, right?
Sort of, but with the back roads.
Okay, so let's talk about the roads being closed. What do you mean by that?
Well, Sheridan Road was closed off, and I'm trying to remember. I don't think there are a lot of roads closed off. I couldn't tell you exactly their names right now.
Was that because there was construction going on?
No, they were closed off because of the riots.
They were closed off to keep people out of the area, right?
Yes.
And you knew there was a curfew that night, right?
I believe I got an emergency alert text at around 8 p.m.
Just like everybody else, saying stay off the streets.
I'm sorry.
Objection. There's no curfew charge.
It's still relevant to his decision making. Just like everybody else, you got a message saying get off the streets at 8 o'clock that night, right?
Yes.
And despite that message, you came down, correct?
I was already in Kenosha downtown when I got that message.
Once you got that message, you didn't decide, I'm going to leave and go home like I'm supposed to, correct?
I stayed at the car source.
And you knew that there was this curfew in place that meant you shouldn't be there anymore, correct?
There were, I'd say, hundreds, if not thousands, of other people there that night that also got the same message.
So if they're all breaking the law, you can too?
I don't think the curfew was really being enforced.
So if a law is not being enforced, you can disregard it?
Your Honor.
It's argumentative.
You said that there was a time in which Nick Smith asked you guys to drive him down to Chicago
Correct.
to buy a piece of body armor
Correct.
down by O'Hare.
Correct.
And you guys were willing to do that at first.
Dominic was willing to do it. It was more of Dominic's thing because Nick Smith was going to give throw in like $20 to Dominic when he bought it for like gas.
So Nick Smith was going to pay $20 for the gas to drive down to O'Hare where Nick Smith was planning on buying this body armor.
Yes.
And he needed that body, or the idea was the body armor would be used that night, correct?
I believe so.
That's why there was some urgency about going down right away, right?
Yeah.
This was part of the plan to come down to downtown that night, right?
He wanted to go to O'Hare to buy the body armor, so yes.
Do you understand my question?
Can you rephrase
Sure,
it?
absolutely. The urgency to get that body armor that day was because he needed it for that night, right?
Well, I wouldn't say he needed it, but he wanted it.
And instead of making the drive, you gave that your own body armor to Nicholas Smith.
Correct.
You had it along with you.
Yes.
You brought it along with you that day because you thought you might need it yourself that night, correct?
No, I kept it in my trunk of the car. I always had it.
You drive around with body armor in the trunk of your car regularly?
Well, it was just in the back of my trunk. I never really took it out.
And you said at some point that day you went to Jelinski's. That's the hunting goods, fishing store out on Highway 31 and 52nd Street to buy a couple of slings. Is that right?
That's correct.
And this was one sling for you and one for Dominic, right?
Yes.
And you bought two of the identical type of sling, correct?
Yes, the cheapest ones they had.
And that's a single point sling, meaning it attaches to the gun in one location, correct?
Yes.
And then it wraps around your body, correct?
Yes.
And it's designed to help you retain possession of that weapon, correct?
You'd probably know more about them than I do. I just got it to hold the rifle. So when I'm doing medical aid, I don't have to sit on the ground and have to worry about it being stolen.
Because you realize that you couldn't have that gun on you while you're doing any sort of medical aid, correct?
I knew that I couldn't, without a sling, have it on me. That's why I got the sling, so I could have my hands free.
But even when you had the sling, there was a time in which you took off your entire gun apparatus and handed it to Joanne Fiedler because it was in the way of you trying to treat someone, right?
At that instance, yes, because it was hitting the ground. The rifle was hitting the ground. When I bought it, that was the purpose of it. I don't think it really worked, now that I think of it.
This big, long AR-15 really got in the way whenever you tried to help someone, right?
Sometimes.
If you had a handgun, for example, it would have been physically more easy for you to try and treat someone. Fair?
If I could have legally carried a handgun, I would have carried a handgun instead of a pistol. I mean, instead of a rifle.
Well, you couldn't legally carry the rifle either.
You grabbed some medical supplies from Dominic Black's house before you came downtown that night, correct?
I grabbed extra gauze, but that's about it.
You testified earlier that your AR-15 was loaded with 30 rounds of ammunition. Is that right?
Yes,
Where did that ammunition come from?
that was from our last trip up north, from May, the time we took it up north.
So when the gun was left at Dominic Black's house, it had that ammunition with it?
The ammo was in a box. Magazine. I don't really know.
When you were at Dominic Black's house on August 25th, you found that AR-15 downstairs in his basement, correct?
No,
Where did you find it at?
it was downstairs in the basement, but I was told by Dominic Black, "Hey, go downstairs, grab your rifle."
So you knew up until that point that rifle was being stored in a gun safe in the garage, correct?
Correct.
And you didn't have the code or any access to that gun safe, correct?
I did not.
It just happened that on this particular day, Dominic Black's stepfather had moved that gun into the house, correct?
Yes,
You didn't know that beforehand?
I didn't.
You didn't know that it had been taken out of the safe?
No.
And so you went downstairs and grabbed it.
After instructed to do so by Dominic, I did.
And it had that magazine?
After I was instructed to do so by Dominic, I did go downstairs and grab it.
And it had the magazine already inserted in the rifle?
It did.
And the magazine was already loaded with 30 rounds.
I believe so.
When did you chamber a round?
I don't know if I ever did.
Well, you had to have to fire the gun, right?
Yeah, I think it was already chambered when I got it. That's what I remember. I don't remember racking it at all that night.
Because the way this type of gun works is that you have to have a magazine with ammo in it. You have to insert the magazine into the gun, and then you have to rack it to load one of those rounds into the chamber, correct?
Yes.
And you were familiar with how to do all of that, correct?
Yes.
And it can't discharge a bullet unless a bullet is racked into the chamber, correct?
Correct.
And so your testimony here, as best you can recall, is that you never had to do the initial racking because the bullet was already in the chamber when you took possession of it that day. Is that fair to say?
I believe so. I believe that it was already racked.
And the ammunition that was in that was full metal jacket ammunition, correct?
223 full metal jacket.
223 being the caliber,
Yes.
and full metal jacket being the type of casing, correct?
Yes. Full metal jacket is the bullet type.
The bullet type. Okay, I apologize. And you're aware there are different types of bullets, like hollow point bullets, correct?
Yes. Yes.
And when you were in the process of purchasing this gun, well, let me back up for a second. You said that the 30 rounds of ammo were left over from previous. I assume you mean when you were up in Ladysmith
Yes.
and you were practicing with the gun up there?
Yes.
And Dominic Black's family has some sort of firing range or shooting range up there, is that right?
They have a gravel pit where it's safe to shoot.
And you and Dominic would practice with your AR-15s shooting at targets in that gravel pit, correct?
Correct.
And you would shoot at targets as far as, 75 yards away?
No.
How close were the targets?
I think the furthest I ever got was maybe from me to the TV.
You didn't shoot at any targets farther away than that?
No.
Dominic Black testified that he shot at targets 75 yards away. Did you see him do that?
I didn't, but I don't know what Dominic Black saw or what Dominic Black was shooting at. I wasn't with him when he did that.
But you were aware of the fact that the AR-15 was capable of hitting targets much further away than you to the TV, correct?
I believe so.
Did you know the capabilities of your own weapon?
I knew that it could shoot, and I believe from a distance. I don't know how far. I'm not an expert on AR-15s.
Did you personally purchase that .223 full metal jacket ammunition?
I did not.
Who did?
Dominic did.
Did you ask him to purchase it?
I did not.
So you didn't know what type of ammo was in that gun. Is that right?
I knew they were 223 full metal jackets. The first time I shot it, I had to load it into the magazine.
So you knew the type of round, but you didn't know what those rounds were capable of doing. Is that fair to say?
Believe a bullet's a bullet.
As you sit here today, you know that there are different types of bullets, right?
Yes.
You know that hollow point bullets, for example, do different things to a animal or a human than full metal jacket bullets, correct?
Yeah. Full metal jacket is a defense round, like another type of defense round. I know people use full metal jacket for hunting, and hollow point is something that causes more damage.
Hollow point bullets are designed to hit the animal that they're being shot at. Let's say a deer, for example, and explode inside that body, correct?
No, I don't think so.
When you say explode, are you saying expand or explode? Because there are such things as exploding bullets.
Sure. Let me rephrase. Mr. Rittenhouse, what is your understanding of what a hollow point bullet would do if it were shot at, say, a deer?
I don't think people use hollow point.
That wasn't my question, sir. What is your understanding of what that bullet would do? Let me rephrase it then, because you're aware that people use hollow point bullets in their pistols to defend themselves against other people, correct?
Yes.
Ryan Balch, for example, testified in this trial that he was carrying a pistol loaded with hollow point ammunition for self-defense. Do you remember that testimony?
I do.
So what is your understanding, if you have one, as to what hollow point ammunition would do to a human?
I believe it would do the same thing as any other bullet. Like I said, a bullet's a bullet. I just believe hollow points. I'm sorry, I don't know much about ammo. I'm trying to think of what I remember, but I just don't know much about ammo.
So you didn't know the difference between what a full metal jacket bullet would do versus a hollow point, right?
I believe a hollow point I just don't know much about this. I believe a hollow point would cause more damage
to the first target, but it wouldn't continue through to any other targets, right?
I don't know the answer.
Whereas
to
a
that.
full metal jacket bullet is specifically designed to continue through its first target and keep flying, correct?
First of all, the hollow point is not guaranteed to stay in the first object struck, which is, so what you said was not correct. Secondly,
there's no testimony on that, Your Honor.
no, but you've been testifying, and that's what Mr. We're going to take a break for lunch. Please don't talk about the case. Read, watch, or listen to any account of the trial. We'll see you, let's hope, at about 12:45.
Do those two 12:45.
Oh, I've got a couple of hearings. Lengthy. Let's say 1 o'clock. I apologize for taking time away from you.
That had come out at the trial. Statutes and
Dang it.
re-admonished
Crap.
to Mr. Rittenhouse previous statutes and then re-admonished him on that. Prior to Mr. re-admonished him on that. Prior to Mr. Rittenhouse
I
re-admonished.
do this quite often.
The second time the court had he was admonished.
Okay.
First time he was admonished by the court. The second time the
They
court had the
didn't
jury
even know. It
leave
wasn't me.
and re-admonished him on that. Prior to Mr. Rittenhouse testifying, this court addressed various things with not only Mr. Rittenhouse, but with the lawyers. You had cited various statutes, and then you had asked if anything would be coming up on, for example, I think 90608. One of the other things you addressed was 90404. And you had said that based on the information that had come out at the trial, nothing had changed as it relates to your ruling. Shortly thereafter, Mr. Binger stated, and we looked it up, previously, he said to Mr. Rittenhouse, previously indicated that you wish to have your AR-15 to protect someone's property. Clearly in violation not only of the prior ruling that you had made, but the ruling that very day, that very morning. It appears to be that there are two really elements the court must consider when making a determination on a mistrial for what amounts to prosecutorial overreaching. And the first one is the prosecutor's actions must be intentional in the sense of a culpable state of mind in the nature of awareness that his activity would be prejudicial to the defendant. I would argue to you that that's clearly aware of that. You had warned him, you had told him prior to Mr. Rittenhouse testifying that these things, certainly the 90404 was off limits. You had warned him about the infringement on his constitutional right to remain silent. He did it again. The second one, I think, requires some action by the court in terms of a finding. The second one says the prosecutor's actions was designed to allow another chance to convict. That is, to provoke a mistrial in order to get another kick at the cat because the first trial is going badly, or to prejudice the defendant's rights to successfully complete the criminal confrontation at the first trial. Now, the case that I had cited is a Kenosha case, State versus Coping.
Opening?
Yep. 100 with second, 700.
COPENING?
Yes, sir. In that case, the court didn't make findings regarding the prosecutor's actions. So I don't know that it's my role to sit here and say who's winning. I don't think that's necessarily what I'm supposed to do. But I think the court has to make some findings as it relates to the bad faith on the part of the prosecution. And if the court makes a finding that the actions that I had talked about were done in bad faith, then I think both elements for mistrial with prejudice have been met. And I think under the circumstances, based on what I've put forth on the record, I would certainly ask the court to consider those. And I would ask the court grant the motion with prejudice. Thank you.
Thank you. State?
Your Honor, I would like an opportunity to more fully respond to this with a little bit of research. At first blush, though, and I reserve the right to present case law and additional sites to the court, but I do want to point out for the record that the defendant has presented interviews to at least one media source and at least one online source since his arrest. And there have been questions about that night. There have been questions about what he did, things like that. He has decided, probably on advice of counsel in those circumstances, not to give a statement in the media about what happened. But he is talking about his family life. He's talking about his friends. He's talking about the circumstances of the case. He's talking about how this has affected him and things like that. So my point in asking those questions was, you have agreed to talk to the media. You've agreed to talk about yourself. You've agreed to give interviews. But until now, this is the first time you're explaining your actions. And so I wasn't referring to his in custody statements. In fact, I never asked either detective about what the defendant told them. He actually starts to tell them some things, and then he says he wants a lawyer, and they stop him. They Mirandize him first, by the way. Then he starts to tell them some things, and he says, but I want to talk to my lawyer. And they're like, okay, we're done. So I'm not referring to that. I didn't ask any questions of the detectives about that. But since this, the defendant has spoken to the media. He has talked about his life, about circumstances related to this case. He just hasn't given his exact version of events that night.
Yes,
So
we're asking
his
about
voluntary discussion to speak to the media has nothing to do with the Fifth Amendment. That is his own decision. And if he's going to pick and choose what he wants to talk about in those voluntary interviews with the media, then I think that's fair game. It doesn't implicate his Miranda rights. It doesn't implicate the Fifth Amendment. He's making his own voluntary choice.
Well, wait a minute. You don't think he could give an interview about his awards he won in high school, or his demerits that he got, or his and about his sports activities and his swimming and that, and declined to answer any questions about the incident in question, and that somehow a waiver of his right of silence?
I think he's doing more than that, Your Honor, in these interviews.
I don't know. I knew nothing about them. I haven't seen I haven't seen probably 1% of all the evidence, which is pretty typical, as you know. So I have no way of knowing it. You have some interviews that he gave to media or to whatever?
Yeah, there's an interview that we're looking at on our computer right now from the Washington Post, where he talks to them. I know there's one, I think it's either the New Yorker or the GQ magazine, where he speaks to the reporters also. And he doesn't go into specific details about what happened that night, but it's not like it's talking about school or swimming or things like that.
No. Just don't leave it at, he doesn't go into specific details. I mean, it's certainly, there could be a waiver, but a very modest discussion about the activities of that night. And if you're suggesting that occurred, that could make a big difference. But even a small discussion on his part of the night in question might be a full waiver. I don't know, but I won't know until I see it. But why don't you make copies of it and?
Can we have a few minutes to
Well, we won't do it right now. I do agree with you that this is not something that I would want to do sitting here without giving you an opportunity to respond. Although I would be interested in your preliminary response to the excluded evidence that you touched on after having been told not to do it, or having been told that I was confirming my prior rulings.
I do want to just point out right now, we've got it on the screen. This is a Washington Post article, and there's reference to an interview that he says, the defendant says he did not regret having his gun because, quote, I would have died that night if I didn't, end quote. So that's a direct quote from the defendant to the media about that night.
What about that?
Your Honor, all I can say about that interview is there were prior counsel representing him.
I don't care about that.
Well, and I believe it was a telephone interview. I don't know anything about the circumstances of that. I'd have to read the article.
Well, that might make a difference. And what about the you're asking questions about excluded evidence?
Your Honor, we went over this earlier, and I don't want to repeat myself because I know you've heard me, but if I could just summarize. I did hear you talk about that evidence this morning before testimony. The defendant then took the stand. He admitted that he had said to the person in the yellow pants that he had pointed the gun at that person. I have seen that video. It was actually introduced by the defense. I think it was even in their opening statement. And there's this person who confronts the defendant and accuses him of this. Frankly, to be honest, Your Honor, when I watched the video the first time, I didn't hear the defendant's reaction. I thought it was someone making an accusation and then the defendant walking away as if trying to avoid a confrontation. I was surprised to hear the defendant admit in his testimony on direct by his attorney that, yes, I did tell that person that I had pointed the gun at them. He explained then that he was joking when he said that. The jury can evaluate that. It goes to his credibility. It goes to whether or not he's telling the truth. It goes to his decision making. That is, again, this is an incident that occurred that night, so it's not something that happened separate in time. It presumably happened a few minutes before. But like I said, I was taken aback by the defendant admitting that he had said to this person, yes, I pointed a gun at you. And I think it's fair to say that watching that video, that person, believes strongly that this happened. The defendant is telling him it happened. Now the defendant today is giving us a different version and saying, oh, I made it, I was joking, I was just kidding that guy or whatever. I'd like to probe that. I'd like to probe what he said to that person. I'd like to probe what his motivations were, etc. I'd like to probe whether, in fact, he really did do that. And I think that changes the equation with regard to the CDS video that was the subject of the other acts motion. Because in my mind, it is very similar. And I know we've disagreed on that, and I'm not going to belabor the point, Your Honor, but that was where I was coming from, was there's been a change in the testimony of the defendant today that I think makes that evidence it's admissible and much more relevant than it already was. And I thought it was already relevant. And the court is, I do want to be clear
So
also.
I'm just here on the sidelines, just
Well,
I had made a ruling that the evidence wasn't coming in, and you decided that it was.
If I could just respond to that briefly, Your Honor, I was about to say, I did not interpret your ruling as an absolute. We've had 3 state motions in the There was one in which we asked the court to introduce evidence that the defendant was at Pudgy's bar with Proud Boys, and you were clear that is not coming in. There was,
Don't get into other subjects. Come on, what you're telling me, you're an experienced trial attorney, and you're telling me that when the judge says, I'm excluding this, you just to take it upon yourself to put it in because you think that you've found a way around it? Come on.
if I may finish, Your Honor, I was about to say that your ruling on our 3 motions and other acts motions was, there were some gradations there. That you were clear that some things were absolutely out, and then you left the door open on other things. So I saw that distinction, and I thought to myself, clearly I know this is out, but you left the door open on other things. So I didn't interpret your ruling as this is absolutely never coming in, and I have practiced before you, Your Honor. I have filed other acts motions before you. Your practice oftentimes is to reserve ruling on those until you see the evidence. And I think you even said something to that effect at our motion.
I undoubtedly did.
So I thought, this is my good faith explanation to you, and if you want to yell at me, you can. My good faith feeling this morning after watching that testimony was you had left the door open a little bit, now we had something new, and I was going to probe it.
I don't believe you. There better not be another incident. I'll take the motion under advisement. And you can respond. When you say that you were acting in good faith, I don't believe that, okay? Let's proceed. Everybody in good faith. All right. Would you come up, please, Mr. Rittenhouse?
I do have,
Yeah.
Your Honor,
Yeah.
I do have another item that I want to raise before the jury comes in and raise it with you. There was another acts motion with regard to the defendant being at Pudgy's bar after a court appearance in January in which he poses for selfies wearing a shirt that says free as fuck. I would like to ask the defendant if he posed for selfies after a court appearance with members of the public wearing that shirt. I do not intend to talk about who those people were, what groups they were affiliated with, or anything along those lines. But I believe that it is relevant when the defendant goes to a bar after a court appearance and poses for selfies wearing a shirt like that. I think it is relevant to some of the issues that have come up in this case. For example, is remorse or lack of remorse, is utter disregard for human life. Those are things that I think it comes into play because I think that behavior is not consistent with someone who.
That was a dumb decision to wear the shirt, but I don't think it's relevant to anything going on in court. I'm sure some of you might disagree with me. But I think it was him celebrating that he got bail.
As a regard for human life. The jury's already watched him break down on the stand with emotion. I'd like to probe how heartfelt and sincere these emotions are when you go to a bar and you pose for selfies with people, when you're out on bond in a first-degree intentional homicide trial wearing a free as fuck shirt. So, as I said, I want to use the photograph. I'm not going to talk about any of the people or who they were from. In fact, the photograph I'm going to use has actually got their faces blocked out, so we won't see any of the people in the crowd. We'll just see the defendant standing with a group of people for a selfie with that shirt on. That's as far as I want to go.
Handle this issue.
Nobody got an opportunity. First of all, you've made a ruling on it, and it was clear prior to him testifying. So part of this is, would we have raised it? Would we have brought it up if we would have known that it was going to be coming in? We have done there's been nothing to open this door, Judge. Nothing that has been said to open the door about what happened 4 months after this is relevant in any way to what happened that evening. That is part of what the court had ruled. You had said 4 months after, I don't see how that goes to any 90404 type of admissible evidence. So my argument is, A, you ruled on it previous to him testifying. You confirmed your ruling, which you had made previously, where Mr. Binger just said you had shut the door on it. So apparently he doesn't believe a door that is shut should stay shut. However, now he's asking that something be admitted that, to be fair, this should have been brought up sooner. This jury, I did the voir dire. I would have voir dired on an issue of whether or not they heard it, saw it, were aware of it, how they felt about it, whether it had an impact on their ability to be fair in the case. We never went there because of your prior ruling. So there's nothing that's opened this door. And I don't think it's relevant, something that happened 4 months later. He talks about indifference to human life. That's that night, not 4 months.
He's not old enough to have alcohol. He's 18. That's why he couldn't have been in a bar. Maybe it was a restaurant that had a bar, but it couldn't have been like a bar because he couldn't have got in. Not old enough.
Later, there's nothing that's relevant about that. You've already made your ruling. I ask that you stick with it.
I'm struggling with why it would be relevant to any of the issues in this case. If he were on trial for using exquisitely bad judgment, if he were on trial for behaving in a very offensive way, then I could see the purpose. But an incident that occurred 4 months after the incidents in question, I don't see how that jury can work with that in reaching any conclusions about the issues in this case.
First of all, Your Honor, we have introduced evidence that the defendant had a slogan on his TikTok page, "Grow up just trying to be famous."
Binger is an idiot.
This case has made him famous, and he's posing for selfies as a result. One of our theories of this case is that his behavior that night was intended to gain attention, to be famous, and he's reaped the benefits of that. Second of all, he is on trial, in my opinion, for exquisitely poor decision-making. Taking a gun that he's not legally entitled to have, coming down in violation of the curfew, running around the community with that gun, trying to be a police officer when he's not, confronting protesters that he knows are hostile, and all of those behaviors, I think, are exquisitely bad judgment. So the jury can make that decision. The jury can give what weight they want to this evidence, but it's moments after he has a court appearance here. He's out on bond in this case when he decides to do this behavior, and nobody made him do it. Nobody forced him to go to the bar.
I wonder if that's why he has different attorneys now.
Nobody forced him to wear the shirt. Nobody forced him to pose for selfies. It's his own decision making.
When I made reference to exquisitely poor judgment. I was talking about at the incident when he was wearing the shirt. Because everybody in all of humanity at one time or another
I forgot Kyle was still sitting on his stand all day.
displays bad judgment, sometimes exquisitely bad judgment. And we don't let it into people's trials on unrelated matters. So I wasn't referring to his having had good or bad judgment on the day in question. That's a legitimate inquiry, and you're being allowed to present a lot of evidence on that subject. And the jury is going to be instructed in some of the element of some of the crimes that are charged here is going to deal with the caliber of his judgment. But you're talking about an incident that occurred 4 months later. So I'm not seeing it, and I don't want to waste any more time with it. I don't think that I've ruled before it's not admissible, and I have heard nothing to change my mind about that.
It was sought to be admitted earlier for a different purpose, Your Honor.
I'm sorry.
It was sought to be admitted earlier for a different purpose than it is today. The court has ruled that it can't be admitted for the prior purpose, but I'm seeking to introduce it for a different purpose today.
And that request is denied.
Thank you.
Okay. Are we ready to go?
I wish we could make kids understand that being an adult is not as great as it seems. Just enjoy it. Just sit back and enjoy it. Because when you get to be an adult, you're like, I want to be a kid again. I love all the shirts that are like, I'm not adulting today, or I can't adult anymore, or whatever. It's like, if kids would just understand how fast childhood goes by and how being an adult is not as great as it seems, the world would be a better place. I'm not anti-guns, but I've never shot one. I wouldn't mind learning how to use one, but I'm not in a rush to go out and learn how to use one either. Huh? Okay. Yeah. Yeah, I went. There were characters out yesterday, and by the time I got to them, they were leaving. All I saw was a back of Mickey going into the backstage area. I was mad.
All right, good afternoon, folks. And
We all are.
I've sustained the objection to the last, so let's proceed.
I didn't chase him away. He didn't even see me. All I saw was his back. He was already going back. Jen might have scared him
Good
away.
afternoon, Mr.
Jen
Rittenhouse.
was there before I
Good
was.
afternoon.
Following her.
You testified earlier that there were times that evening when Mr. Rosenbaum had threatened you. Is that right?
Yes.
And you described him as wearing a red shirt with a
That's
blue
true,
bandana.
Debbie.
Is that correct?
At certain times.
When he threatened you, that's what he was wearing?
How old do you have to be to go into the service? You have to carry a gun in the service. Can't you go? That was just yesterday, Marty. I was better. That was just yesterday. Yeah. You can go into the service when you're 18, right? Or younger. How old can... Shoot, I don't have... I got an AI thing on my phone. How old do you have to be to go into the service?
You need to be at least 17 to join the military.
17 with parental consent. So if you're 17, you can carry a gun in the service. Yeah, that makes no sense. Oh, you can have a gun? I thought you couldn't have guns at all in the UK. You were in stream yesterday, John?
I believe the first time he threatened me, he was wearing a red shirt with the blue bandana. The second time, he had it wrapped around his face.
Had what wrapped around his face?
His T-shirt.
So he wasn't wearing a shirt the second time around.
Correct.
And you indicated at one point you thought he had a chain in his hand?
I believe so.
When he made the threat to you with the red shirt on and the blue bandana, did he have the chain in his hand?
I think one of the times he did.
Okay, and so which of the times was it?
I can't recall off the top of my head. I think it was the time when he was threatening to cut people's hearts out.
And I don't need to know the threat, I just need to know which time it was. Was it the first time or the second time?
Second time, the second time.
What was he wearing the second time?
He was masked. Well, the shirt wrapped around his face.
And he didn't have a shirt on his torso.
Correct.
And you could see when he didn't have a shirt on his torso that he didn't have any gun tucked in his waistband, correct?
I wasn't paying attention to that. I was behind Joanne Fiedler. I was somewhere over there.
So how far away were you from Mr. Rosenbaum when he made the second threat?
By 10, 15 feet. I'm not really certain.
But you were close enough to hear the words out of his mouth.
Yes.
And you took that as a threat to you personally?
I took the first one where he said, if I catch you alone, I'm going to kill you. I took that as a threat to me personally. The second time, I took that as a threat to the group.
Can we have that photo, exhibit 138 up on the screen, please? Do you see Mr. Rosenbaum in this picture?
I do.
And he's in the middle of the picture wearing the red shirt with the blue bandana, carrying the plastic bag, correct?
Yes.
Is that the way he looked when he made the first threat to you?
When he said, if I catch you alone, yes.
And he was carrying that plastic bag with him when he made that threat too, correct?
Correct.
How close was he when he made that first threat to you?
Close. I couldn't give you an exact estimate, but he was close, less than 5 feet.
So closer than Madam Court Reporter is to you now?
I'd say about the same, if not a little bit closer.
And you were next to Mr. Balch when that was said?
Correct.
Was anyone else there besides you, Mr. Balch, and Mr. Rosenbaum?
I believe there were other demonstrators around.
And you've seen in this trial that there's been a lot of video footage of that night, correct?
Yes.
And you've seen in this trial that there's a lot of video footage of you that night, correct?
Yes.
You'd agree with me that there's no video of either one of these threats, correct?
I don't know if somebody filmed it that I'm aware of right now.
You're not aware of any, are you?
I'm not.
So Mr. Rosenbaum looked like that at the time of the first threat, but then looked different at the time of the second threat. Is that right?
Yes.
And Did you say he was carrying the chain when he made the first threat or the second one?
The second.
Okay. And he was still carrying that plastic bag the second time?
Yes.
That plastic bag has a clear side to it that allows you to see inside of it, right?
Sorta. I didn't really look into the bag.
So you didn't know what was in the bag at all?
I didn't.
Did he swing the chain at you when he made the second threat?
He did not.
Did he physically touch you when he made the second threat?
No, he didn't.
In fact, that entire evening, he never once touched your body, did he?
He grabbed my gun when he attacked me.
And that's why I asked the question the way I did. He never touched your body that night, correct?
He didn't touch me physically.
Okay. And neither the first or the second time did he run at you or charge at you or anything like that, did he?
He didn't chase me.
He didn't even do anything physically aggressive to you, did he?
No.
He just said some words.
Yes.
And that chain that he had in his hand, he never did anything to physically threaten you with that chain, correct?
Yes.
Is that correct?
That's correct.
And other than the chain that you've described, at no point in the evening did you ever see Joseph Rosenbaum with any other type of weapon, correct?
Not that I saw.
Never saw him with a gun,
Correct.
never saw him with a knife,
Correct.
never saw him with a bat,
Correct.
never saw him with a club.
Correct.
How far apart in time were these two threats that you say Mr. Rosenbaum made to you?
I want to say I can't give you a definite time. I wasn't looking at my clock, but I'd say within the same hour.
And both of those threats occurred while you were on the 59th Street property?
The second threat happened at the corner, and the first threat happened towards Ruther Central High School.
Okay, could you use that laser pointer and point out on that map where the first threat occurred?
The first threat happened right here in front of the building.
So you're pointing at a location that is by the 59th Street car source on the south side of that property, along the building and Sheridan Road on the west side of the road. Would that be accurate?
Yes.
Okay. And you said there was a second threat within an hour after that, correct?
Yes.
Where was that threat at?
It was somewhere over here, I remember, like on the other side of the property towards Ruther Central.
More towards the northeast corner of that same property.
Correct.
But you were still on the car source property when that second threat was allegedly made, correct?
Yes.
Did you remember what Mr. Rosenbaum had said to you later on when he's confronting you at the 63rd Street car source?
I took a mental picture of his face. When he said those threats, I recognized that was him that said that when he started chasing me.
So when you are running away from him at the 63rd Street car source, you're thinking to yourself, this is the guy who had made a threat to me earlier. Is that fair to say?
I was thinking this is the guy that said if he catches me alone, he'll kill me as I'm running away from him.
The reason I asked Mr. Rittenhouse is, how did you know it was the same guy when he's changed the way he looks?
His appearance, the shorts, his height.
But in both of those instances that you've described, he's got something covering his face, either the blue bandana in one instance or the red shirt in a different instance, correct?
He was wearing the red shirt when he chased me around his head.
So you remember that from the second time that you say he threatened you?
Yes.
And you thought to yourself, this is the same guy?
Yes.
So when you eventually were getting to the point where you're going down to the 63rd Street car source, right before the shooting, you recognized him as you're following down the street, didn't you?
I didn't follow Mr. Rosenbaum down the street.
He was in front of you. You know that now, right?
I know that now.
But you didn't, You didn't see him ahead of you as you're walking down there that night?
No, it was dark out.
But you, at some point as you get close to the 63rd Street car source, start running towards that lot, right?
Towards the fire that in the Duramax.
And Mr. Rosenbaum is running ahead of you, isn't he?
I don't believe so.
But you decided you needed to run because of the fire in the Duramax?
Yes.
Why? What was so urgent?
It was a fire.
There's fires all over the place, so?
I was getting to the fire to put it out.
We'll get back to that in a second. You indicated that while you were at the 59th Street car source, you said you put out a fire at the church next door. Is that right?
Yes.
Did you hear Joanne Fiedler's testimony yesterday that when you guys went over there, somebody had put some sort of flammable liquid on the door? Did you hear that testimony?
I did. I believe that was referring to the Ruther Central High School.
Okay, so when she described it as happening at the church, you think that was, she was getting it confused?
Yes.
Yes? Okay. So whatever happened with this flammable liquid on the door, the point is some other group, some other people put that out before you even got there.
Correct.
Why did you feel that you should go around off the 59th Street car source property and put out fires?
To make sure my community didn't get burnt down and help.
And when you say your community, you mean Kenosha?
Yes.
Again, you're from Antioch. You're not living in Kenosha at this time when this all happens, right?
My dad lives in Kenosha.
Lots of people live in Kenosha, but you didn't, right?
My residence was in Antioch.
Okay. But you felt like you wanted to do things to protect this community. Fair?
The community that I was part of, yes.
And you felt like it was appropriate for you to take matters into your own hands to put out fires, for example.
To put out fires by using a fire extinguisher, yes.
Even though they weren't on the 59th Street property, correct?
Correct.
And were there other things that you decided it would be appropriate for you to go out there and take care of off the 59th Street property that night?
I was walking around and asking people if they needed medical help.
So you felt that you wanted to go out and help people, help protect people, help people feel better, treat people, things like that, even off the 59th Street property.
Provide first aid.
Normally in our regular society, that's something that we call 911 for, right?
Normally, yes.
Where are we headed?
I think that the defendant's decisions to go off that property and involve himself in other matters are relevant, Your Honor.
Well, I'll let you pursue it, but
And that's exactly how these shootings happen. So
well, that's what the trial is about.
which is why I
go
think it's
ahead.
relevant.
Go ahead. Go ahead.
Normally, we would, if there's a fire, if there's somebody committing a crime, you call 911, right?
Normally, yes.
You didn't feel like you could do that night, correct?
I don't think that I saw from the nights prior that the fire department wasn't responding to put out fires.
Well, the nights before, there were businesses on fire along 22nd Avenue. There's the car source, large scale property fires on the prior nights, correct?
Yes.
On the night of August 25th, we didn't have any fires like that. We just had a couple dumpsters, smaller things, right?
That I saw, yes.
I didn't hear you, sir.
That I saw, yes.
But regardless of how big the fire is, you felt that night that calling 911 was not an option, correct?
I didn't feel that if I called 911, anyone would show up.
Which is why you decided to take care of it yourself, correct?
provide first aid and put out fires.
To do the things that normally we would expect the police or the fire department to do, correct?
To help people, yes.
Could you please move that microphone a little closer so we can make sure we hear everything you say? You can adjust it if you need to move it a little closer. Thank you.
Let me, permit me to interrupt for just a moment. How's the temperature? How many are comfortable the way things are? Okay, I won't even ask the other side. See you ice cubes, there's nothing to worry about. It must be blowing differently here. Go ahead, Mr.
You came to Kenosha that night armed with the AR-15 and no other ways to physically defend yourself, correct?
I had an AR-15, yes.
Other than that, you had no other weapons or devices that you could use to defend yourself that night, correct?
Yes.
There's an interview in which you say you're not carrying anything non-lethal. Do you recall that?
I do.
You indicated in response to one of your attorney's questions that there was no friction with the protesters that night. Did I understand you correctly?
By friction, you mean?
Well, I'm using your words, sir. I heard you say in response to your attorney's question that there was no friction with the protesters that night. Did I hear you correctly?
Yes.
And you're describing what you observed when you were at the 59th Street car source. Fair enough?
Yes.
So based on your several hours at that location, it seemed to you as though the crowd of, however you want to describe them, they've been called rioters, protesters, demonstrators, and you, things were fine. No tension, no friction, no nothing. Fair to say?
For the most part, other than Mr. Rosenbaum.
He was the only one
That threatened, yes.
that you saw.
Yes.
Can we please play exhibit number 18 at the 1 hour and 22 second and 22 minute and 14 second mark? Okay. Can you please play from this point?
And militia are up there.
We need water. Yeah, we got a fire.
Where? Oh, dumpster fire.
Yeah, just a dumpster fire. Hey, it's just like the year, man.
Yeah, right. If 2020 is a blunt, it would be just a fucking stem.
It would just be stem and seed, man.
I could use a doobie right now.
Hey, cover me, I got this. All right, let's. Hey guys. Morning. How's it going? Guys want
Normally, we would, if there's a fire, if there's somebody committing a crime, you call 911, right?
Normally, yes.
You didn't feel like you could do that night, correct?
I don't think that I saw from the nights prior that the fire department wasn't responding to put out fires.
Well, the nights before, there were businesses on fire along 22nd Avenue. There's the car source. large-scale property fires on the prior nights, correct?
Yes.
On the night of August 25th, we didn't have any fires like that. We just had a couple dumpsters, smaller things, right?
That I saw, yes.
I didn't hear you, sir.
That I saw, yes.
But regardless of how big the fire is, you felt that night that calling 911 was not an option, correct?
I didn't feel that if I called 911, anyone would show up.
Which is why you decided to take care of it yourself, correct?
To provide first aid and put out fires.
To do the things that normally we would expect the police or the fire department to do, correct?
To help people, yes.
Could you please move that microphone a little closer so we can make sure we hear everything you say? You can adjust it if you need to move it a little closer. Thank you.
What just happened?
Let me interrupt for just a moment. How's the temperature? How many are comfortable the way things are?
Okay, that was weird. What is going on?
See you ice cubes, there's nothing to worry about. It must be blowing differently here. Go
Okay,
ahead, Mr.
all right.
You
I don't know what's
came
happening.
to Kenosha that night.
Okay. That was weird because the video was about to end and I was trying to get into StreamYard on my laptop. Oh, you can't hear me. I'm sorry. I'm sorry. I was trying to get into StreamYard on my laptop because the video was about to end. So I was just going to let it play out to the end. But it actually went to another video and kept going. And I guess it overlapped a little bit. So I guess we're still on whatever day this is at the trial. That would have been a good joke, though, John. That would have been a really good joke. So I need to check and see if the vote is still the same. So we did day 1 of the Brendan Banfield trial. So I put a poll up. If I can find my own channel here. Because some people said that it was boring and we missed so much. Yes, we're moving, Marty. So the poll was skip the rest of the trial, pick up wherever they are when I come back, or pick up where we left off. And someone said, to be honest, it's not worth going back to because the defense is a hot mess. And you guys know I like hot messes. So, it was skip was 29%, pick up where they are was 21%, and pick up where we left off was 50%. So we saw day 1. So we're going to start with day 2, which Miss Thang's still on the stand. His au pair. So she's still on direct, but I think it's going to shortly jump to yeah. I decided I needed Jill in my life last Easter because it was so cold. It was still so cold last Easter and snowing everywhere. And I said, oh, the poor little kids are going to have to find Easter eggs in the snow. And Jill said, don't paint them. Give them a challenge. And that was when I decided that Jill was my new best friend. So we're going to go over there. It should redirect you. It never redirects Marty for some reason. I think it's because he's on mobile. I really do, but I don't know. Anyway. Okay, so we're going to jump over there. So we'll be back with more of this tomorrow morning at 8. I will be back at 8. As much as I hate getting up that early, I will be back at 8. Okay, so if you're not going to join us, I will see you guys tomorrow. If not, you'll be redirected over to the au pair trial. So I will see you there. Bye, guys.